I think I'll go ahead and get started. Hello, everyone. My name is Joe Newhouse. I am chair of the Institute for Transnational Arbitration, or ITA. I want to welcome you to the first session of ITA's four-part seminar focused on the draft code of conduct for adjudicators in investor-state settlement. ITA is presenting these seminars as a public service in view of the immense importance of the draft code. 3 years ago, the UNCITRAL member states gave UNCITRAL Working Group 3 the mandate to determine the need for and form of potential reform of the investor-state resolution dispute resolution system. The draft code is the first element of that reform process and promises to be an extremely significant development in the ethics of international adjudication. Requested by the state parties to UNCITRAL and ICSID, it will inevitably have a sweeping influence on arbitrator disclosures and conduct in investor-state arbitration, as well as more generally in ISDS reform. You will hear a bit more about the creation and the drafting process shortly. We are presenting this week a four-part in-depth examination of the most important issues with which the draft code proposes to grapple. In each seminar, a panel of the world's leading experts on the question being discussed will put the issue in context, with a focus on the state of the law and practice. They will then move on to the specific requirements, the draft language, and issues left open in the draft code. Today, the issue will be issue conflicts. That is, where an arbitrator may have written on or taken positions on an issue that arises or may arise in arbitration. On Wednesday, we will focus on the double hatting problem, where arbitrators also sit as counsel or in other roles in arbitration. On Thursday, the topic will be repeat appointments by a party or counsel of the same arbitrator, and we'll finish up on Friday with questions of implementation and enforcement of the draft code. ITA is proud to host this review at this early stage of the development of this important instrument. We are particularly proud that a number of the experts from whom you will hear are members of ITA's advisory board and its academic council. In fact, Chiara Giorgetti, one of the principal drafters of the draft code and one of today's moderators, is chair of ITA's academic council. So let me introduce Chiara and her co-moderator, Tom Sikora. Chiara is a professor of law at Richmond Law School in Virginia. She teaches and writes in international law and international dispute resolution, and her present research focuses on the selection and recusal of arbitrators. She came to teaching after a very active practice at White & Case in Washington and La Live in Geneva. Chiara in 2019 and 20 served as scholar in residence at ICSID, and in that capacity took a lead role in drafting the draft code. Tom Sikora is senior counsel in the International Disputes Group at ExxonMobil Corporation in Houston. Tom manages international commercial and investment arbitration for ExxonMobil. Prior to joining Exxon, he practiced at El Paso Corporation and at Vincent & Elkins. Somehow, on top of his day job, Tom has been a leader of ITA for years and is today the senior vice chair of the Institute. Chiara and Tom have put together an extraordinary program with an outstanding faculty, and ITA cannot thank them enough. Let me now turn the virtual podium over to Tom and Chiara.
Many thanks, Joe, for this very kind introduction. It's really a great pleasure to be here today to discuss the important topic of issue conflict and how it is addressed in the draft code of conduct. We are delighted to have some really renowned experts to help understand what is the issue with issue conflict and if there is an issue at all. We are grateful to each one of them for joining us today. Let me introduce them briefly in alphabetical order. Dominique Bramberset practices mainly in the field of international dispute resolution, in particular international arbitration and contracts and international business transactions, as well as in matters involving international private and public law issues. She holds a law degree from Lausanne University Law School, Paris 1, and Harvard Law School. She was called to the bar in 1982, and she has acted as counsel, co-counsel, and arbitrator, also as a sole arbitrator and president of arbitral tribunals in over 200 international cases around the world, including in cases involving states and international organizations at both private and governmental levels. She has a particular interest and experience in early settlement tools related to arbitration. She's on the panel of arbitrators of several arbitral institutions, in particular ICSID, the JCAA and the Hong Kong International Arbitration Court. She's also the ITA Vice Chair of this. She's one of the ITA Vice Chair for the Executive Committee. Next, Anna Jubin-Brett was a Secretary of the United Nations Commission on International Trade Law and the Director of the International Trade Law Division of the United Nations Office of Legal Affairs since November 2017. As such, she's also provided secretarial service to Working Group 2 and Working Group 3, which deal with ISDS reform. Prior to her appointment, Ms. Jubin-Brett was a practicing attorney at law in the Paris Bar. She specialized in international investment arbitration and investment dispute resolution, and she's focused on serving as counsel, arbitrator, mediator, and conciliator in international investment disputes. She has served as arbitrator in several ICSID, UNCITRAL, and ICC disputes. And prior to 2011, for 15 years, Anna was a senior legal advisor for the United Nations Conference on Trade and Development. She's very well known. All the speakers are very well known to all of us. So, of course, this is a summary of all of their wonderful accomplishment. Martina Polaszek is Deputy Secretary General of the International Center for the Settlement of Investment Disputes. She joined ICSID in September 2001 and has served as Secretary of Tribunals in over 50 arbitrations under the ICSID Convention, the ICSID Additional Facility Rules, and the United Nations Commissions on International Trade Law Rules. She has also served as committee secretary in numerous annulment proceedings. She has published numerous papers on ICSID case law and practice and regularly speaks at conferences. Before joining ICSID, she worked as an attorney with law firms Jean Tet & Associés in Paris and White & Case in Prague, focusing on international arbitration. Ms. Polaszek holds degrees from the Georgetown Washington University Law School and LLM, University of Paris 5, René Descartes, and the University of Göteborg. She's admitted to practice law in Washington, D.C. Lucy Reed joined arbitration chambers in New York in January 2020 as an independent arbitrator, following several years in Hong Kong and Singapore as head of the Freshfields International Arbitration Group, and then as professor of practice and director of the Center for International Law of the National University of Singapore. Lucy is president of the International Council for Commercial Arbitration and vice president of the Singapore International Arbitration Center Court. Having formerly served as president of the American Society of International Law, chair of the Institute for Transnational Arbitration, and vice president of the ICC Court. Lucy has represented private and public clients in many investment treaty and complex commercial arbitrations, and sat as arbitrator in over 50 cases, including as commissioner of the Eritrea-Ethiopia Claims Commission. While with the US State Department, she served as the US agent to the Iran-US Claims Tribunal and senior lawyer on investment disputes. Lucy is qualified in New York and was educated at the University of Chicago Law School and Brown University. Catherine Titi is a tenured research associate professor at the French National Center for Scientific Research at the University of Paris 2, Panthéon-Assas. She serves as the steering committee of the Academic Forum on ISDS, whose work contributes to the discussion of UNCITRAL Working Group 3, and in addition to be a member of the Academic Council of the Institute for Transnational Arbitration of the Center for American International Law, she also sits on the board of the European Society of International Law. Catherine is a fellow of the Chartered Institute for Arbitrators, and she sits on the panel of arbitrators of the Court of Arbitration for Art. She's appointed to the roster of the United States-Mexico-Canada Agreement, Annex 31B panelist. She has previously been a consultant at the United Nations Conference on Trade and Development. In 2016, Catherine was awarded the prestigious Smith Lowenfeld Prize of the International Arbitration Club of New York for Best Article published in the field of international arbitration. We are really grateful for each of you for joining us today. Each expert will speak twice today for about 5 to 8 minutes. The first time they will address the issue of the complexity of defining the issue conflict and the implication really of this difficulty. And then in the second round, they'll focus on disclosure requirement, which is provided in the draft code. We will leave time at the end of their presentations for a Q&A, and we urge all all of you who are listening to please use the Q&A function at the bottom of the screen to ask your question. We will make sure that your questions are collected and hopefully answered. Thank you very much, and I'll pass you over now to my colleague and co-moderator Tom to introduce the issue more. Thank you very much.
Thank you very much, Chiara, and thank you, Joe, for your kind introduction. What is issue conflict? Is there really such a thing, or is it just a version of the question of impartiality or bias? In his 2013 decision on a challenge brought by India to the Honorable Marc Lalonde as president of the tribunal, and Professor Francisco Orrego Vicuña as co-arbitrator, ICJ President Peter Tomka addressed it in the following way. The basis for a challenge invoking an issue conflict is a narrow one, as it does not involve a typical situation of bias directly for or against one of the parties. The conflict is based on a concern that an arbitrator will not approach an issue impartially, but rather with a desire to conform to his or her own view. In this respect, some challenge decisions and commentators have concluded that knowledge of the law or views expressed about the law are not per se sources of conflict that require removal of an arbitrator. Likewise, a prior decision in a common area of law does not automatically support a view that an arbitrator may lack impartiality. Thus, to sustain any challenge brought on such a basis requires more than simply having expressed any prior view. Rather, I must find, on the basis of the prior view and any other relevant circumstances, that there is an appearance of prejudgment of an issue likely to be relevant to the dispute, on which the parties have a reasonable expectation of an open mind. Judge Tomka's discussion is a useful starting point to the consideration of how to address the ethical issue and therefore often heard criticism of the investor-state arbitration system. What makes the current system of ad hoc arbitration different from other formats of dispute resolution, including those with standing tribunals, is that we get to select arbitrators of our choosing. And thus, it follows we should not be able to manipulate the system by picking arbitrators who adjudicate nothing because they have already prejudged the dispute. But where is the line between intellectual predilection formed by life experiences and prejudgment of the specific dispute? Can it be defined? Must a bright line be declared? And must conduct beyond it be regulated? The draft code does not attempt to prohibit or regulate the question of issue conflict directly, but it certainly does not ignore it. Of course, it requires that all adjudicators be independent and impartial, but it also goes further. It requires broad disclosure of all prior ISDS cases in which the adjudicator took part in any of the multiple roles of arbitrator, counsel, or expert. And it further requires a list of all publications and, in a bracketed section, relevant public speeches. It is the latter set of disclosures that the drafters admit in the comments are intended to address issue conflict. In other words, the draft code addresses the question of issue conflict by mandating broad disclosure and leaving it up to the parties armed with this information to decide whether to challenge the adjudicator on this basis. It is this approach and possible alternatives that our distinguished panel proposes to address. Let us start by hearing from Martina Polasek, our colleague from ICSID.
Thank you. I'm very pleased to be here on behalf of ICSID. Before we get to the discussion on whether or not an issue conflict should in fact be a conflict of interest, I think it's useful to discuss what we mean by issue conflict. We might be talking about the same general problem, an arbitrator prejudging an issue in the case, but we might be talking about different factual scenarios of prejudgment. And not everyone agrees that all these scenarios should be defined as an issue conflict. There is no consensus on what factual scenarios actually raise issue conflicts. Some of these scenarios concern uniquely the arbitrator's preformed view on an issue in dispute. They go more to the state of the mind of the arbitrator, so more to the question of impartiality. But other scenarios involve a relationship or an interest that might cause the arbitrator to prejudge an issue in dispute. So they deal with both impartiality, but also the arbitrator's independence. Now, it's important to consider these various possible scenarios in the context of the Code of Conduct, because there is no rubric that says issue conflict, and the term is not defined in the Code of Conduct. The commentary to the code does mention issue conflicts in connection with the disclosure of publications, that's Article 5, but it does not take position on what an issue conflict scenario is. My main role today is to describe the various scenarios that have been argued to be issue conflicts and give some examples of cases that have dealt with challenges on this basis. The first scenario concerns the arbitrator's publications. The arbitrator has previously expressed a general legal opinion in writing on a legal issue involved in the case. An example of this is the ICSID case, Urbazer versus Argentina, where an arbitrator was challenged because he had, among other things, taken position on the question of extension of an MFN clause to procedural matters. And in that connection, he had called the Maffesini decision heretical. The argument was that he had prejudged an essential element of the dispute. Now, the other members rejected the challenge, saying that the mere showing of an opinion was, in their view, not sufficient to sustain a challenge for lack of independence or impartiality. There have been a few cases with this scenario, but none of the challenges in the public domain were upheld, as far as I'm aware. The second scenario concerns the arbitrator's public or other statements, could be about the case or about a party. So for example, in Camphor versus the United States, the arbitrator appointed by the claimant had made certain public remarks about the state's measures that were argued to show bias and prejudgment of a contested allegation in the arbitration. Now, he was challenged and he then resigned, so there was no decision on the challenge, but there had been a few cases upholding similar challenges, although this scenario is quite uncommon as well. Now, the third scenario concerns the arbitrator's previous or concurrent arbitral appointments. So this is the situation of repeat appointments or multiple appointments. And this can raise several issues. The first is that the arbitrator has addressed a similar legal issue in a prior decision or award as an arbitrator. And this type of challenge has rarely been successful, and most decisions have said that the fact that an arbitrator has made a determination of law or a finding of fact in one case doesn't mean that they cannot decide the law and the facts impartially in another case. But there is one notable case that Tom has already mentioned, the CC Devas versus India, the UNCITRAL case that was decided by the president of the ICJ, who upheld the challenge to one of the challenged arbitrators on the grounds that the arbitrator had participated in 4 prior awards in which he had been confronted with the same legal concept based on a similarly worded essential security clause in a bilateral investment treaty. The awards that he had rendered had been annulled, but he continued to defend them in writing. And so this was seen to have prejudged the issue, and there was no way that the arbitrator was going to be convinced otherwise. Now, it does get a bit more complicated if there is a close interrelationship between the facts and the parties in the previous case that the arbitrator has ruled on and the pending case. And the concern is that the arbitrator has is privy to information from the first case that is not in the record of the second case, and that he or she could prejudge the legal issues on the basis of the facts in the other case. Now, an example of a successful challenge involving this type of scenario is Karatu versus Kazakhstan, where there were very significantly overlapping facts. Another issue with previous appointments is an arbitrator's multiple appointments by the same party or counsel. Now, this could also involve similar legal facts or similar facts and legal issues, but it has an additional element. It puts into question the arbitrator's independence, as they might feel indebted to the party or counsel who appointed them. Now, I won't go into this here because we have a separate panel dealing with this, but just to note that this could be part of an issue conflict scenario. The fourth scenario is the double hatting scenario. The arbitrator acts or has recently acted as counsel in another case dealing with same or similar legal issues. And the concern is that the arbitrator would be inclined to rule on that issue in the same way as the argument that he or she is making as counsel, because it would benefit his or her client. And there are different views on whether this should be defined as an issue conflict and whether on the merits, this should actually be a conflict of interest. And we also have a separate panel dealing with this scenario. The final fifth scenario is when an arbitrator could prejudge an issue in the case based on some relationship with a party, the party's affiliate, counsel, or experts who act before the arbitrator. Now, for example, the challenged arbitrator had acted as counsel in another case in which he had retained the same valuation experts as those appearing before him as an arbitrator. So to conclude, I hope that these 5 scenarios show that the concept of issue conflict has a very broad scope when it is argued in practice. And I think we have to be mindful of that, especially when we use the term issue conflict in the abstract, so we make sure that we're talking about the same scenarios. Thank you.
Thank you very much, Martina. Madam Secretary.
Thank you very much, Tom, and thanks to the organizers at the IPA, Joe and David, for having me today, and to our 2 moderators, Chiara and Tom. Chiara is a member of the academic forum that supports the work of the UNCITRAL Working Group 3, and she has published together with Mohammed Abdel Wahab a paper on the topic we're discussing today, and Tom is a standing member of our Working Group 3, where he represents the Association of In-House Counsel. So thank you for having us here and for allowing us to kick off with you this series of webinars with the topic of issue conflict. And as Martina very rightly said, it's interesting to choose this topic because the term issue conflict does not appear in the draft code of conduct as such. And it's addressed under draft Article 5 on conflict of interest and disclosure obligations. So here under 5.2 comes the issue of issue conflict in the form of a duty to disclose a list of all publications by the adjudicator or the candidate, and that is in brackets, and their relevant public speeches. Just for the benefit of the audience, what you find in brackets in the draft code is, of course, are, of course, elements that when drafting, we thought that it would be interesting to have them there for discussion purposes, but they also highlight the fact that they may be more difficult to address. So what the Code of Conduct seeks to do here is to elaborate on the avoidance of conflict through a broad disclosure obligation. It puts the responsibility of making all reasonable efforts to be aware of and to disclose any interest or relationship that could affect independence or impartiality on the arbitrator or the adjudicator. It provides for disclosure to be made promptly, and it's a continuing obligation for the arbitrator or adjudicator. And the draft then further suggests that candidates or adjudicators should err in favor of disclosure if in doubt, but should not, of course, disclose trivial interests. Now, by way of background, and as mentioned by Joe in his introduction for this specific provision, the working group early on in April 2018 had identified issue conflict as a possible issue to be considered and as a concern in investment arbitration, in noting that some individuals act as counsel and as arbitrators in different ISDS proceedings, with the possibility of ensuing conflicts of interest and or so-called issue conflicts. Now, a lot of time was spent discussing and deliberating on double hatting, and we will be talking about that tomorrow or day after tomorrow. But issue conflict was again deliberated upon when we discussed the possible code of conduct that would be encompassing all issues related to decision makers. And in the last session, when it was deliberated upon, the working group noted that with respect to issue conflicts, the preparatory work should first take guidance from existing work done in the area, including the ACIL-ICA Task Force report on issue conflicts in investor-state arbitration, and two, include possible options while ensuring that they would not inadvertently prevent qualified academics and others from serving as ISDS tribunal members. Now, what is important to note, also by way of background, is that the working group has insisted upon not only the existing or a factual set of issues or problems or concerns with investor-state dispute settlement, but also the perception of an issue. And here, when it came to actually issues of conflict of interest, what the states wanted is to ensure that we address the perceived and not only the factual issues. So this brings me to suggest that it's indeed important to define what issue conflict is about, but it's also important to bear in mind that even if we do not find a clear and factual definition for issues conflict, we also have to be mindful that this was considered as a concern and that as such it merits our attention. Thank you, and back to you, Tom.
Thank you very much, Madam Secretary. Professor Lucy Reed, we'd love to hear from you next.
Thank you, and good morning, everyone. I'm no longer a professor, but that's all right. My main point is that the complexity of defining issue conflict is illustrated in the draft code by the overlap of issue conflict, double hatting, and disclosure in Articles 4, 5, and 6. My submission is that it's difficult, not impossible, but difficult for one person, say Miss X, to first advocate with full commitment for an investor or a state client in an ISDS case, and two, sit as an adjudicator in an ISDS case, given that most cases turn on more or less overlapping issues of FET, full security and protection, expropriation, and damages. Now, typically, this is not a situation that's caught by Article 4.2D. In other words, it's highly unlikely that Ms. X is going to use her adjudicator's position to advance a private interest and throw the FET decision in her case to assist her client's position in the case. I think that's pretty far-fetched. But as Anna said, doubts are raised under Article 4.2b. Her financial and professional interests may be seen to influence her judgment as an adjudicator. It's complicated if Ms. X is a partner in a law firm. It's particularly complicated if her firm has an active ISDS practice with many partners involved. And that's the reason why many years ago, when I was head of the Freshfields International Arbitration Practice Group, we were maybe the first to set the policy that no Freshfields partner could sit as an ISDS arbitrator, because the issue conflicts may not be known when a case starts, but they come up later. Now, I recognize the argument that many people make, which is that a good advocate pursues the best interests of her client, whether she's committed to it or not. And therefore, she can be independent and impartial as an adjudicator, because no two cases are exactly alike on the facts and the law. But when I think about the code of conduct, I consider two things. One, the constant self-doubt that one has as an adjudicator when also serving as counsel or having their partners serving as counsel in similar cases is not good for the system. And more important, the perception of states and general counsel of investors in particular, that there's professional promiscuity or hired guns is not good for the system. And so what do you do with a code? I think we have to remember a code is soft law. It's standards for arbitrators to look at their own conduct. So it's self-judging in a sense, it's not regulatory. Would a definition of issue conflict help? I think we've heard Anna and Martina say, and I agree, it's impossible to have a definition. It's going to be case by case. But I do think that guidelines with examples, more than are in the commentary right now, would help immensely. And for that reason, I mentioned, as Anna did, the 2016 report of the joint ASIL ICA task force on issue conflicts in ISDS. That's ICA report number 3. It's downloadable from the ICA website. The bottom line of that report is it's important to distinguish between what the task force called unobjectionable predisposition and inappropriate prejudgment on issues. And so, while we know there can't be hard and fast rules, they set out 3 criteria, and I'll conclude with these. The first is the degree of commitment, the character and the depth of the adjudicator's commitment to prior views. For example, the C.C. Devis case. The second is timing and propinquity. If you stick to double hatting, concurrent service as an adjudicator and counsel is more likely to create a risk or an apparent risk than having done one or the other in the past. And third, there's the question of the specificity or proximity of issues. Is it the same sector? Are the parties overlapping? And therefore, the closer the issues are in 2 cases as counsel and as adjudicator, the more likely it's a problem. Thank you.
Thank you, Lucy. Dominique? David, you're going to have to unmute Dominique.
I'm very sorry.
Perfect.
Okay, great. I'm asked to address the issue of independence. Well, Catherine is going to address the issue of impartiality, which is more often referred to when it comes to issue conflict in decisions taken in ISDS cases, for instance. But independence also has its importance. As you know, many of the international courts ask or require that the judges be independent. They don't speak of impartiality. And I'm sensitive to that as from the jurisdiction I come from in Switzerland, where until now, it will soon change. The Arbitration Act requires arbitrators to be independent, but not impartial. Don't be shocked. Cases has developed the concept that independence encompasses partiality. The Federal Tribunal has stated that partiality, or impartiality rather, is the necessary corollary of independence. So there is always a slight difficulty already when we try to, when it comes to issue concept, to distinguish between issue concept which may relate to issue of independence of the arbitrators or impartiality. There is a very small difference between the two concepts. As already stated, usually independence refers to independence from the persons, or as I will submit, from the subject matter of the cases in some cases. And partiality is more something which has to do with predisposition, a state of mind, and I will leave that to Catherine. In Switzerland, for instance, I see an interesting comparison with what is the discussions which are going on now regarding the code of conduct with what happened in the past regarding CAS arbitration. As you know, the seat is in Switzerland, and so when there is an application to set aside an award or issues of challenges, this is handled by the Federal Tribunal, which is our Supreme Court. Very early on, it became very obvious that there should be no double-hatting, and of course, Lucy will be happy about that. It was obvious for everybody because at the beginning, a tiny group of specialists in sport law started to be counsel and arbitrators in almost every cases. They saw no difficulty. They argued that they had done so all their life in commercial arbitration and that there was no difference there. The Federal Tribunal criticized between the lines such an approach, stating that to establish its reputation amongst the athletes and not only the sport federation, CAS had to be perceived as being a truly independent body. And so double-hatted was prohibited. I'm not aware of issue conflict in CAS cases, but it could happen, I suppose. The closest cases we had were setting aside proceedings against an award in which the chairman of the arbitral tribunal in a CAS matter had given a legal opinion to one of the federation involved, had advised on a code of conduct, and he had disclosed that. He was not challenged, no question were put to him, and after the fact and after the award, this was raised to dispute the proper constitution of the arbitral tribunal, because the sanction of a non-independent arbitral tribunal may be that the award will be set aside later because of improper composition of the arbitral tribunal, which should be independent. This can lead to challenge proceedings and sometimes to both. In that particular case, the parties waited until the end. There is no real obligation to disclose as specifically as in the draft code of conduct now, but Swiss law and cases require that arbitrators should investigate pay attention to their cases and be sensitive to the fact that if they don't disclose issues which may, in the eyes of a third party, objectively give rise to doubts as to his or her independence and impartiality, should be disclosed. This is going to change on the 1st of January 2021. Swiss law will now specifically require an obligation to disclose in Article 179, paragraph 6, which will be of the PI Act, which will be new. And it has added, we are told by the federal government message, in order to reflect case law, has added impartiality to independence as a requirement for arbitrators, despite the fact that everything is included. So I think this sort of gray line also on conflict, issue conflict regarding matters of independence in some jurisdiction or impartiality adds on to the difficulties the prior speakers have raised about the fact that there is no strict definition, that it is impossible of issue conflict, that it can take many forms. There has been only one case so far in Switzerland which has specifically raised issue conflicts. I was counsel in this case as a respondent. The other side tried to disqualify an arbitral tribunal entirely on the ground that they had been criticized by the institution controlling these proceedings for being late, for having issued contradictory positions, and there were two setting aside proceedings on partial awards. They tried to challenge the arbitral tribunal on the ground that it would be totally impossible for it to be independent, let alone impartial, in light of their prior decisions, and they raised the issue of intellectual bias, which is very close to issue conflict in terms of maybe independence. These setting aside proceedings were not accepted, and the arbitrators, the federal tribunal, confirmed the case. I'm not aware of any other cases, but if the code is adopted, as there are several cases, as you know, cited in Switzerland, it would be interesting to see what the federal tribunal will say. And it is one jurisdiction in international matters which has some experience in the field, albeit limited. Thank you very much.
Thank you very much, Dominique. Professor Titi.
Thank you very much, Tom. Thank you very much, Chiara, and all the organizers. It's wonderful to be in such great company. I'm going to address the issue of prejudgment. Inevitably, there are going to be some small overlaps with things that speakers have already said. I'm surprised to find how much I agree with what speakers have said so far. So looking closer at the question of prejudgment, I would like to start actually by taking a step back and saying that what matters from my viewpoint is whether we have a question of impartiality or independence, not if we have a question of issue conflict in general, since issue conflict can mean everything and nothing. So what is prejudgment? The assumption that the adjudicator has actually already decided on the issues in dispute because of their previous awards, dissenting opinions, publications, and statements. And I cannot stress this enough, a distinction needs to be drawn between prejudgment and issues such as double hatting, for instance. That may be challenged, where the adjudicators may be challenged because of an assumption of a lack of independence or impartiality. So I'm looking closer at the question, the narrow question of prejudgment. A distinction needs to be made between expressing an opinion on the facts, that is case specific, and expressing an opinion on the law that is abstract, such as an opinion that one expresses in a publication or in a speech or in a dissenting opinion. And one thing that comes to mind is the question of the generality of a statement, of a legal interpretation that one makes, such as in a publication. I'm possibly influenced by the fact that I'm currently writing a monograph on equity in international law for Oxford University Press. So I've been thinking about how equity functions. And there what one finds is that because the statements that law makes are general, sometimes situations come up that do not fall into the general statement. So exceptions then may have to be created. In the same way, when one makes an argument, a legal argument in a publication, they have not very probably foreseen all possible situations that may fall under this general statement. And what exactly is an issue conflict? Is it an issue conflict if one writes about fair and equitable treatment? Does that mean that person cannot decide a case involving fair and equitable treatment? And then is every interpretation an issue conflict? So what if someone discusses fair and equitable treatment in the USMCA and they say that fair and equitable treatment in the USMCA is the same thing as the customary international law minimum standard of treatment, which is something that is provided for in the treaty? Does that mean that they have prejudged the interpretation of fair and equitable treatment in the USMCA? Another issue that comes to mind is that to the extent that we think that there is a need to create consistency in decisions, I say to the extent that we think, so please don't consider that I have prejudged the issue, and I think that is how it should be. Then one should stick to one's own previous awards, but one should also stick to previous awards in general. So where is the issue conflict there if one, for the sake of consistency, tries to stick to something they have already done or said before? I would also like to stress that sometimes one may change one's mind, and this is something that also comes with maturity. The more one learns about an issue, the more one is, I don't want to say likely to change one's mind, but the more one is likely to find that things that they have thought to be the truth in the past are not necessarily so. Another issue is concerning disclosure of speeches, that one has no transcript. I mean, one may have a paper that comes up with a presentation, but very often one doesn't. So can you judge that there is an issue conflict from the title of a presentation? So if someone provides a list of presentations they have given, and if so, very often the titles are actually given by the organizers. So to conclude, am I trying to say that there is no problem with prejudgment? No, I'm not saying that. There may be questions where there is an issue with prejudgment because the adjudicator has in fact decided the issue. But again, the issue is a problem when it is a question of impartiality or independence. I'm a little skeptical about a blanket need to disclose everything that might send out the wrong signal. It may create a presumption of partiality or lack of independence if one has expressed opinions in a particular matter that may not always be there. And I think that the problem usually arises out of related situations such as double hatting. And I will close with a final line that that I think is very important. Every case must be decided on its merits, and it's very difficult to judge in general, to offer a phrase that covers every situation. Thank you.
Thank you, Professor Titi.
Many thanks to all the speakers on the first round. We really addressed a lot of very significant issues and really explain the complexity of the definition of issue conflict, right? So starting from Martina's 5 grounds in which tribunals have found issue conflict, really on the other, Catherine's helpful distinction between something that is an issue conflict can mean anything or nothing, or a very narrow understanding of issue conflict as more as a prejudgment. And then I thought Lucy was very interesting how the ICSID task force really said, so we have a possibility of looking at specific issues of 3 ways in which we can define issue conflict, looking at proximity and the degree of commitment, and really looking at how the definition of issue conflict can be informed. And the idea also that one of the problems about understanding issue conflict is that we have so much diversities between how it is perceived, how it is applied, and also within different systems, legal systems, as Dominic mentioned, for example, under the Swiss regime. But at the same time, as Anna said, the state parties to look at the working group 3 said, well, we have to try address issue conflict, and we have to see how to address it in the code of conduct. And so our next question would really be, so the way in which issue conflict has been taken into consideration in the code of conduct, as all of you have mentioned, is essentially requiring disclosure. And Article 5.2d says, well, one of the ways in which parties can understand or perceive or maybe try to assess whether there's an issue conflict is requiring adjudicators to disclose really as much as possible, and specifically in 2D, a list of publications and possibly bracketed text of published statements. And I wonder if you can tell us a little bit of your view about this, what kind of your view about the disclosure requirements in draft code, and whether it is helpful how the code is drafted, and maybe how it can be refined in the discussions. And Dominic, could you start maybe off by telling us a little bit about the scope and the scope of the disclosure in the draft code, and if you can comment on that?
Thank you, Chiara. My first reaction when I first saw Article 5.1d was, just saying, well, this is an issue not for me, but for the academics. I wrote a few articles. I know you see that I'm wrong. I wrote a few articles, but nothing like most of you have done. You are teaching, you are professors, and it's part of your obligation to write and to develop the law. And it's funny, this morning I received a decision from the Paris Court of Appeal about a case in which I was an arbitrator, out of the blue. And I read that one of the grounds raised against the award in that case, in which I was co-arbitrator and not chairing, was the fact that I had been appointed after the original choice of the respondent had declined because he had a conflict or I don't know what. And 15 or 16 years ago, I wrote one of my very few articles, because I stopped thereafter for a number of reasons, with this person who does a lot of ISDS cases. And when I accepted my appointment, I had no idea that he had declined, firstly. Secondly, this was never raised during the arbitration. It had to do with a bankruptcy and arbitration, which was not at all an issue in the case at stake. And it was raised to challenge the award in Paris on the ground that I could not possibly be independent and impartial, having written this article with the arbitrator who had first been appointed. That the fact that I was chosen indicated that the respondent really were trying to influence the composition of the arbitral tribunal. It was dismissed by the Court of Appeal. I'm told it's going to go in cassation, so it will be interesting. This article I wrote so many years ago immediately raised issues for me when I first started to act as an arbitrator. There was many cases in which it was raised by a party to say that they could not agree to me chairing because I had written this article, which in all honesty, I could not even tell you exactly what it was in detail because I forgot. After that, I realized that if you're a practitioner, as I was until recently also as counsel, firstly, it's very difficult to take the time to write anything meaningful, and secondly, it's most likely to be retained against a possible appointment depending on what I write about, which is generally issues which interest me and that I come across in my cases naturally. So I was surprised that this letter D was there. I think it's great that it is, because I think it's a very important issue. Even if it's not adopted as such, we need to discuss it. Everybody has to realize that it could be an issue, particularly in ISDS arbitration. It gives me the feeling that the states are not treated as sophisticated parties when I read this, because I don't see any parallel duty of on the parties, in particular, including the state, to do their due diligence on the arbitrators. It is as if everything, the burden is entirely on the arbitrators, including on issues such issue conflict, which, as we just heard, is almost impossible to define clearly. It's on a case-by-case basis. I will close by the analogy with CAS that I was making earlier. In CAS cases, the federal tribunal put a very heavy burden, perhaps too heavy, on the parties to inquire and to do their due diligence. They don't accept that there is a disclosure obligation which goes beyond the obligation that any party to a contract, in casu, it would be the arbitration agreement, the receptum arbitri between the parties and the arbitrators, imposes on the parties to disclose everything in good faith. So the arbitrators has a duty, but equally the parties have also a duty to inquire. And I think perhaps this is what is missing in this pretty harsh draft of Article 5 at the moment. Perhaps a sort of more balance between these two duties, and the relevant speeches. Katharina raised a very good point, and very often people participate to conferences and then it appears in GAR or whatever. It's not necessarily expressed in your own words, or maybe you realize that you didn't speak as you wanted to. But that's probably also something which goes a little bit too far. But this being said, I also think that if there was the duty for the parties to also inquire and do their work and be vigilant in good faith, and not just wait until there is a problem to raise it against the arbitrators, it will be very easy if there is an issue which bother the parties based on what has been disclosed, but based on what is publicly available, to ask for the question and be very specific rather than being theoretical. I will close with that.
Thank you, Dominique. Can I ask Lucy what's your view? What's your take on this on the drafting of the code?
Sure. I was specifically asked to look at the potential chilling effect on writers. And as Tom said at the beginning, the only reference to issue conflict in the Code of Conduct is in Article 5 in the commentary, where it states that subparagraph D of Article 5 addresses issue conflict. What subparagraph D says is this: there has to be disclosure of a list of all publications by the adjudicator or candidate, bracket, and their relevant public speeches, bracket. Now, personally, I think that writings and speeches are the least important and the least pernicious indicators of issue conflict. It is very rare for an academic or a practitioner publicly to state a view on an ISDS issue that is so unequivocal, regardless of the facts or the allegations or the law involved in a case, that it's going to be disqualifying. The C.C. Devis case is a notable exception. And anyway, when that does happen, it's hardly going to be a hidden statement from the community. I agree that disclosure, though, it's not just the best protection here, it's really the only practical protection, even if, as Dominique says, more burden is put on the parties to look into the literature. The question is how much disclosure. And let's look at publications. The requirement to disclose all publications. On the one hand, this is not actually a difficult thing for arbitrators to do, because people know what they publish. They have to know what they publish, and most of us keep a list of what we publish. But on the other hand, why disclose all publications, including those that are irrelevant to ISDS? If I've written a chapter on an aspect of commercial arbitration in Singapore, I have to disclose that. If I've written a restaurant review, do I have to disclose that? There's a question of whether that trivial exception that comes at the end of the code can modify the very clear word or phrase, all publications, especially when in the brackets, speeches are limited to relevant speeches. So as I see Anna smiling, as drafting suggestions, I have, you can see I would want to take out all, but I also think that the commentary should say that subparagraph D of Article 5 addresses one aspect of issue conflict, not the only one. But anyway, so you could say, what's the problem? What's the problem if the arbitrators list all of their relevant publications and their restaurant reviews? It's just a long list. What's the problem? Well, I think there's two problems. One is that Article 5.3 traditionally requires a disclosure as a continuing duty. And that means an adjudicator, an arbitrator, is going to have to alert the parties in every case in which he or she is an arbitrator whenever he or she publishes anything. They'll have to update their disclosure statement with new articles and potentially speeches. And that's not going to really be helpful to anyone. It's going to clog up the system. And as for the chilling effect on scholarly writing, Dominique, but also informed commentary by practitioners, will there be a chilling effect? I think we agree we need publications, we need scholars, we need practitioners to write. It helps advance the practice. And I agree there will be a chilling effect if this code of conduct goes in like this. But I don't think it's because responsible commentators and scholars will be afraid to write what they want to write. I think it will be because they have a reasonable concern about being challenged, successfully or not, for having failed to disclose something that someone else catches in the public record. And these problems are going to be magnified if the bracketed language is adopted and adjudicators are required to disclose all relevant public speeches. I'll give you 3 questions on that. The first is, why is this limited to relevant when publications are not? I think relevant should, and relevant to what? Relevant to ISDS. I think if the bracketed language stays in, it should be relevant to ISDS, and I think publications should be relevant to ISDS. I know it's broad, but we could work with it. Second, what is public? Is that only an official conference where you give a speech, or is it a social media post that someone else puts up about something that you have said in a conference? And my third question is, what is a speech? Okay, a keynote is a speech. We know that at an ICA Congress. But what about comments at an ITA Tilney Hall session, where a lot of people hear what you have to say about double hatting? And what about comments during a relatively informal panel, like this one? Does this become a public speech for me? Would I change what I say? Absolutely not. I would say the exact same things. I don't think I'll be chilled. I don't think I'm going to self-censor, but I will have concerns about my disclosure obligations if I remember to put down everything that I say and raise the risk of challenge. And I do think the way the code is drafted right now, there will be an increase in bad faith strategic challenges. And I also suggest, Anna and Martina, that if it should go into effect with all publications and relevant speeches, it should be prospective or back only a few years, because very few of us have kept a record of every panel that we spoke on or every Tilney Hall in which we spoke up. Thank you. Those are my practical observations.
Thank you very much, Lucy. This was very interesting, looking at the chilling effect and the whether the disclosure is, if the disclosure is the right approach, what does it mean, and how much, how far back, and what to include. Both you and
Chiara, could I meant to say something that I think is important.
Absolutely.
That is that it wouldn't hurt the profession if I stopped publishing and speaking. I have my reputation, I'm known, but I do think it will be much harder for younger practitioners and new practitioners to feel that they can't speak out without having their appointments scrutinized or limited. Thank you, sorry.
Thank you very much. Although I really do hope that you will not stop writing, because what you write is extremely, extremely interesting. But I take your point. I mean, what does it mean, the chilling effect, both for established practitioners and a new entry, and the need really to continue talking about some of the issues that are raised in ISDS. Both Lucy and Dominic kind of raised the issue of the party and when the parties come in and the role of the parties. So I wonder if Catherine can say a little bit about that, and what are the consequences of recognizing issue conflict. Maybe briefly talking a little bit about is the disqualification and what you do once an issue conflict has been recognized.
Thank you, Chiara. I would like to start by seconding Lucy's comments, strongly seconding her comments. In terms of the disclosure, I don't see an issue with disclosing itself. Anyway, law firms are going to check what an individual has written. I'm a little concerned, as I said earlier, about the signal that is sent out. Then I will stick to prejudgment lead to disqualification. I would say that in any case, disqualification cannot be automatic. You have expressed an opinion on A, so you're disqualified. That I don't think can work. And I would like to raise the following issue. So what if ICLOS said, if you write on the law of the sea, if you write about maritime delimitation, then you have prejudged the issue, so you must be disqualified. What if the ICJ said, if you write on international law, you may have an issue conflict? If we push this too much, there is a risk that the people who are knowledgeable and who are the experts are not going to be able to sit on the panels, because the people who are the experts, they will have written about ISDS. So I'm a little concerned about this, about a potential lack of legitimacy that may ensue if the people who keep their freedom of expression and work in a particular field and write in that field and give speeches are eventually not able to sit in ISDS cases. And a final consideration is that I think the way I see it, bias has been shown more often along different lines, pro-investor, pro-state, or pro-one's appointing party, rather than pro-one's previously expressed opinions. And I will close with what I said the first time: every case must be decided on its merits. Thank you.
Thank you very much, Catherine. I think you also raised the important issue of, on one side, wanting somebody who hasn't expressed views, but on the other side, wanting an expert to decide issues. So thank you for raising that question also. Can I give you the floor for your comments? Anna? For you.
To me? Okay.
Yes, please, if you can. Thank you.
Yeah, thank you so much. Well, it was just a bit, it came out a bit garbled, excuse me. Yeah, I would like to pick up on a couple of things that have been said, and particularly on the ones that Catherine was mentioning right now. I think it has to, all of this discussion has to remain within a certain measure, and we all know that in the area of ISDS particularly, arbitrators are chosen mainly because they have experience and they have expertise and they have either written or researched or previously encountered the handful of issues that are at the basis of all ISDS cases. So I don't think that the point here is really about preventing people to write, preventing people to research, preventing people from, commenting on a decision that has been rendered, an award. I think that is part and parcel of this practice, and I don't think that this is really the idea behind identifying issue conflict. And I think what really remains, I think, at the heart of it and very difficult to ascertain, and which is key for the parties involved, is to make sure that the arbitrator, having read, having researched, having seen cases previously, keeps an open mind about issues and keeps an open mind about the case at hand, and not be put into a box just because they have previously written, published, researched, or commented. So I don't think this is really what is at stake here. And when we're talking about public speeches and about publications, it's of course only, in my view, the tip of the issue conflict iceberg. If I may use this term, I don't want to play it up as if it were an enormous issue, because I'm not sure it is, but I think that the publications and the speeches are only what is easiest to find or to identify as a clear issue conflict. So what I think is that there still needs a bit, I mean, this particular issue, which once again has been identified by the states as a concern, has therefore to be looked at and not ignored, and decided that, you think that there is a problem, but there's no problem. But that we find ways of dealing with this concern in a manner that is that really tackles this perception of partiality, because you have your mind set on something, and that's where I agree with many of your comments, that the way it is dealt with is maybe not satisfactory, and that it's worth giving it another try. At least that's what I read from your comments. So thanks for that. And the other point I wanted to make is really about what Lucy was saying about, yeah, we write a lot and we speak a lot in various settings, some official, some less official. And I think that one of the beauties of technology that we have currently is that you can keep a database very easily of what you write and what you do, and you just enter into your database that I wrote this and I took part in that. So it should become easier now that we have tools that allow us to do so much easier than when it was only, you know, trying to rake your brain and say, oh, what have I been doing 60 years ago when I was first writing my dissertation on this particular point. Thanks.
Thank you very much. Martina, would you like to add anything?
Yes, very quickly, if I may. Now, I have acted as secretary of tribunals in many cases, as you noted in the beginning, and I often receive questions about what should I disclose? You know, should I disclose this particular situation or this publication? And we've always taken the approach that if you have any doubt, then err in favor of disclosure. And I think that's what, how we approached this in the code of conduct as well, in favor of disclosure, in favor of transparency, so that parties can take position on what they consider as a potential issue conflict in whatever scenario is determined to be problematic. Now, it doesn't take position on whether it's actually a conflict of interest, but we thought that more guidance to arbitrators on what they should disclose is actually a good thing. Now, obviously, we can talk about how broad that scope should be and the burden on the arbitrator. The question that Lucy raised about relevant speeches and publications, all publications. And I thought that the thought behind that was that the very thing that she noted, that you probably keep a list of your publications, while you not keep a list of all your speeches and what are speeches. So of course, further discussion, this was a kickoff draft, so I'm sure there will be further discussion on what all of this should be, and further guidelines will be provided. But I think it's very good that we start up the discussion on these points as well. Thank you.
Thank you very much. I agree. This is very important that we think about all these issues. And of course, we start this series of seminar with the first one on issue conflict. And I'd like to thank you all for very thoughtful contributions about what are the issues, what should we consider. First of all, what is the definition of issue conflict? What should we include? What should we not include? What are the consequences? As Martina has said, and others, the idea is let's try to disclose. So let's have it open in the air. What are some of the what are possible some of the issues, and then think about the consequences. So thank you very, very much to all for very, very thoughtful contributions. We have some times for Q&A, and I've seen we have had a very active participants. So let me start off with some of the questions that some participants have asked us during the webinar. I start off with the first one. Shouldn't we simplify things and narrow down issue conflict to the case in which an arbitrator has demonstrated doctrinal predisposition on a key issue which is likely to, 1, come up in the arbitration, and 2, have a bearing on the outcome of the case? And if that limited definition were to be accepted, which excludes double hatting and repeat appointments, should the precedents of tribunal be held to a stricter standard that party appointed arbitrators, which are naturally going to be chosen by the parties, bearing in mind some of their ideas? I think it's interesting to do these issues. So should the precedents have possibly different standards? And then the narrow down issue conflict. Would anybody would like to take on some of these questions? No, can I ask maybe Lucy, please? Yeah. Thank you.
I thank Manuel for the questions. I'm afraid that it doesn't narrow down anything. to talk about a doctrinal predisposition. It's still going to raise all the issues of what roles are being played, what are the facts in the case, what is the law in the case. It will still be an issue by issue or a case by case review. I would welcome, I don't want to put Anna and Martina on the spot, but I would welcome their view on whether they would even be able to consider putting that into the code as a definition of issue conflict. I don't think it's just doctrinal. On the question of a different standard for the president of a tribunal and the co-arbitrators, I'm dead set against that myself, because while of course we all understand this shadowy world of some acceptable, they say, predisposition by party appointed arbitrators, investor or state appointed arbitrators, I don't think that that's a healthy thing to encourage by having a separate standard for an independent president and independent co-arbitrators.
Thank you. Martina, Anna, would you like to add anything to this?
Yeah, happily. I think it just reaffirms what I was just saying, that the academic writings are, in my view, not really, I mean, they capture only a little piece of what is issue conflict, and they're not, I don't think that they would be sufficient, or that, especially if you call them then doctrinal views, I don't think that would capture what we're trying to do in this code.
Yeah, I have nothing to add. Thank you.
Chiara, this is Tom. I'd like to raise an issue with respect to Article 5, 2D. It talks about the disclosure of all publications, but it is not clear whether by publications we also mean awards. Mm-hmm. And I think it could be construed by some not to include awards. And yet, from a perspective of an issue conflict, what is more relevant than a prior award on a related issue? And so I'd like to ask the panel whether we should clarify as to what our position is with respect to prior awards.
Dominic, I thought you raised your hand first. Would you like to, do you have an issue on the first question or on Tom's now question?
I just wanted, no, I raised before I heard Tom's question, so I will think about it. I think it's very important, I agree with Lucy, to have the same standard for all three arbitrators. Otherwise, we go back to the old system of the so-called party arbitrators of the old days, where arbitrators appointed by the parties, the co-arbitrators, were acting almost like super counsel for them, which was an issue discussed many years ago and I thought settled by now. And I think the same standard should apply to all of them.
Thank you. Martina, you raised your hand?
Yeah, I think this situation is at least indirectly covered by Article 5.2c, which says that all ISDS, that the disclosure needs to include all ISDS cases in which the candidate or adjudicator has been or is currently involved as counsel, arbitrator, annulment committee member, expert, etc. So, I mean, you don't directly say, I've rendered a decision, but it would be very easy to see that there has been an award or decision in that case.
Yeah, I agree that it is, I mean, if the code itself generally requires really disclosure, a very wide disclosure, and requires a disclosure that covers a lot of different issues, a lot of different past cases in different rules also. So I think the idea of the code is really try to disclose as much as possible and then leave it to the parties to decide what are the consequences of this disclosure, so that the arbitrators, adjudicators have the active duty to continue the disclosure and provide as much disclosure as possible. And then the role of the party is kind of later deciding, well, what do we do now that we have all this information? Anna.
Yeah, just to end on a lighter note, I think you have to leave a little bit for the parties to research, because if you ask the arbitrators to also disclose what they said in paragraph X, Y, or Z of a given award, then you know what's left for the parties.
I agree.
Yeah.
Could I just ask a question to Martina and Anna? If I understand correctly, the provision just mentioned by Martina requires a disclosure of all ISDS award and experience. I also understand from the commentary and some articles I read, not all, but some, that ISDS had to be understood in a very broad sense. And it's not limited to ICSID or BIT, but it could be ad hoc cases or maybe ICC cases or SCRE cases. Is this understanding correct?
Yes. Yes.
There's a definition actually of ISDS in the previous part of the code in Article 1.4, where there's a kind of a definition of ISDS also. Yeah. I think some of you have already pointed out to the commentaries, which I think is actually quite helpful in explaining what the different provisions are. And this is very much for the drafting of the code and for the discussion. Before we conclude, do we have any other comments, or would anybody would like to say any concluding remarks? We have 2 minutes. Lucy, please.
I have a question. I can see from the other questions that we haven't addressed that several people are concerned about the responsibility to disclose confidential information, confidential awards, confidential cases when one was counsel many years ago, for example, in a case. I haven't seen any clear guidance in the draft about whether the obligation to disclose awards or positions as counsel includes confidential or excludes, I should say, specifically excludes confidential roles or awards. And that connects to other questions that say, what about strategic bad faith challenges? We can never get away from strategic bad faith challenges. The problem, even if you assume that they're all decided correctly by appointing authorities or whoever gets to decide challenges, it wastes tons of time and money. And I think that the code should do what it can to minimize the avenues for strategic challenges, including someone knowing about a confidential case, for example, in which I was counsel 10 years ago, and they know about it because they were counsel on the other side, and I don't disclose it, and then they bring it up. What happens then?
Yeah, right. That's a good point.
And perhaps the commentary to the code ought to be built out to some degree so that it is clear that the intention of the drafters is to discourage strategic or bad faith challenges based on merely having a view of the law as opposed to having a view of the narrow facts or narrow government measure that is being adjudicated.
Yep.
Yes, absolutely. These are all very, very good points. It is now 10:30, so we are just on time. Let me thank you all very much again for participating today. I think this was a very, very rich and thoughtful discussion. This is the first of our 4 events. We're going to discuss double hatting on Wednesday, repeat multiple appointments on Thursday this week, and on Friday, the issue of implementation of the code. I hope you can join us for the other discussions, and thank you very much to everybody, our panelists, Tom, Joe, David, everybody. Please, thank you very much for participating today, and we look forward to seeing you again soon.